9:21 p.m.
Yes?
Yes, go ahead,
Sorry,
Counsel,
thank you.
sorry.
Hi, Mr. Johnson. I'm going to hand you 11.
Let's go.
You were just talking about following the court rules, and
Sure.
this is your answer. Is that correct?
That's my answer.
And it's what defendants do other than me. They just deny and they don't really go into detail. I know you know when I answer I have a lot of detail. You have opted, let's say it's a notice provision, to just deny without any great details. Is that fair for me to say? Is there anything that you could show me where you are going into details
Yes.
about what, where?
The Rule 11 motion that I filed against you and your
Okay.
client.
You keep talking about that, but I'm talking about the answer.
Well, I'm telling you there's something else that explains the whole story.
So this, well, today's deposition, the court's going to get that.
Perfect.
So you're saying to me that there's no explanation or defense in your defense, no details? There's nothing that says either you did something right or I did something wrong? Is there anything here?
No.
When I say I apologize. My client, are you saying anything he did was wrong in your answer, or that you did something right in any, oh, and the affirmative defenses? Is there anything that properly shows your defense to this
Well,
case?
the pie of blame, your client gets a sliver and you get the rest of the pie. So there's that.
Let's, again, for the record, you keep saying you want to get out of here and stop wasting your time, but you're continuing to attack me when you've already said all these things. Let's just move on, right? So
Let's move
is there
on.
anything in your answer at Exhibit 11 that memorializes your belief that you're not liable in this case?
Yes, I'm going to direct you to the affirmative defenses.
Hold on. Affirmative defenses.
Page ID
And
358.
what are affirmative defenses again?
These are defenses that even if everything you say in your lawsuit is true, I can get out of it with this.
And what are you talking? Oh, a bona fide error.
Yep.
So you're saying, I believe the bona fide error rule, and you know it better than I do, you know a lot of the rules pretty good, is if you did something wrong, I think you called making a mistake, and it resulted from a bona fide error, notwithstanding the maintenance of procedures, reasonably adapted to avoid any such error, then you would get out of the violation because you had procedures set up and you did all you could not to have that accident or mistake happen. Is that correct?
That's a good summation of the bona fide error rule, yeah.
I was expecting you to say I have no clue what you just said, but thank you.
And here's the thing. I have more defenses. Your client waived venue. So all this talk, the hours and hours that you just spent with the minutia of this venue issue, you and your client waived venue in the state court case. And I even offered you guys a chance to change the venue to Bloomfield Hills, and you rejected it. So what was I supposed to do?
You did say all of that. Let's make this Exhibit 12, and I'll go to that.
And your client settled this debt for... I don't know how he can come back in an amended complaint and say that the assignment documentation wasn't up to snuff when he paid it. And there's the statute of limitations. Your client had a perfect statute of limitations defense according to you.
You said he
Yet,
didn't.
I'm not done.
Sorry, I
Yet you
apologize.
you didn't plead that in the state court case. You just settled it. But you could have, I guess, could have gotten him to pay $0.
You literally attached to your
I'm not
mediation
done.
summary and counterclaim that the client had made a payment, and here's the proof.
Right.
So why are you saying the client didn't exercise his right on a statute of limitations defense?
Where's the motion? Where's the motion to dismiss under the statute of limitations? You're suing me for the statute of limitations in federal court. I'm not
sure that I would win.
I'm not finished.
Okay.
Thank you. So he had allegedly, according to your complaint, a great statute of limitations defense in the state court case in Madison Heights, which he never used. You allowed him, even though he had this great affirmative defense, to pay
I'm gonna get there.
Stop. My client the sum of. You claimed that we had a bad venue in this case, yet you and your client waived venue. You had opportunities to change the venue, and you said no. You said the venue in Madison Heights was appropriate for your counterclaim.
All right.
There's more, and I'm not done. Your client settled this. I don't understand. Your client doesn't have standing to sue us because he didn't sustain any damages, because all the damages that are alleged you fabricated with him.
All right, so the Exhibit 11, I'm handing to you. Is that the letter?
I have Exhibit
I
11.
apologize. Exhibit 12, is that what you're talking about as far as offering Mr. Ward the chance to change venue?
Yes, you can see the letter is addressed to you.
All right.
And I'm requesting that you, Brian P. Parker, pay the associated venue transfer fee.
Do you not understand?
Stop! Not my client. Not your client,
All
Mr.
right.
Ward.
Do you not understand agency rules? That I'm an agent? Oh, you do understand agency rules.
And I want you to look at this. Despite this, I'm offering you. Mr.
All right.
Parker, and your client, Mr. Ward, who left. I don't even know why he was here. So I addressed both of you in this little subsection, and then at the bottom I say, I want you, Mr. Parker, to pay the associated venue transfer fee. If I had said you and your client, and you can actually look in this little parenthetical, I reference both you and your client, so the demand to make a venue transfer fee payment was to you and you alone.
Okay. Can I see that letter?
You can have it.
Could you move that microphone to
I'm
your side?
I'm sorry.
I appreciate it.
I'm sorry.
I see what you're doing.
Yeah.
So you want me to pay, not my client.
That's what the letter says.
But you understand that I'm not in the lawsuit. Do you understand that?
You are representing your client,
Yes.
and your client can be, you can be sanctioned by a state court judge, not your
Is that what
client.
you were doing, sanctioning me?
No, I was asking you. I was
Okay.
basically saying, hey, if you're going to sue me over this venue issue, you might as well change it in the actual case that you care so much about, and you did not do that.
Okay, so-
even though you waived venue. So I was just trying to set you up, and you walked right into it.
Okay. So the letter is you saying, Parker, I want you to change venue, and you've waived.
No, I said, look, in this video you said you're going to sue me over this venue issue. So using my thinking cap, I was like, okay, if he's going to sue me, might as well give him a chance to change the venue on his own so he doesn't have to sue me. But obviously the goal of all of this was to sue me, to bring me here, because you want to smack me around, because you want to punch me in the face, whatever you want to do, and that's why I'm here.
Have I punched you in the face today?
No.
Do you expect me to?
I don't know anything.
All
You
right.
said you were going to get a gun in one of your videos.
I did not say that, but that's fine.
Actually,
And
you did. I can
did
play
I
it back
set
for
you
you.
up today? Did I try to harm you in any way?
You brought in special guests. You brought your
She works in
client.
my firm, and my client has a right to be here.
You brought your client, which is highly unusual for a deposition. For anybody.
You said you've had 2 depositions,
I've done a lot of depositions.
and clients have never showed up, either your client or their
Not the
client.
opposing client, usually not. But anyway, it's your client. You can do whatever he wants. I know he has to work, and I know his time is very valuable. I don't know why you would tell him to waste his time in this deposition.
Okay.
Because-
and so,
Go ahead.
oh, so you understand, though, that I'm not in the previous lawsuit. Is that correct?
I do understand that, but I do understand that you could be sanctioned by a judge for your conduct in the previous lawsuit.
Right, and so that's the one you said it was settled. So you think that when you write to me, you're not writing to my client?
I explained to you in depth in the parenthetical. I reference you and your client, yet the demand for payment of the venue transfer fee was made to you and you alone.
But the rule says the client pays.
No, it doesn't.
It
You
says the attorney pays?
It says, I don't even know what it says, but both of you could have paid it.
It says the party that is doing the move pays. I'm not a party, is the point I was trying to make to you. So why would you assume that I am?
Because you
Under
waived
the rule, under 2.221.
Because you and your client waived venue.
All right,
You
moving on.
stop. I want to answer this one in full. You and your client waived venue in the state court case when you filed a response to the lawsuit and you didn't file the associated motion to change venue. Then you filed a counterclaim against my client Security Credit Services LLC, whereby in the venue provision you stated venue is proper in the 43rd District Court in Madison Heights. So that's why I was like, okay, they waived venue, so there's really no issue anymore. Yet, still, then you say in this video you're going to sue me over the venue issue, so I sent you said letter and said, Mr. Parker, we don't have to do that. If you want to change the venue, even though you waived it bye-bye, even though it's way past the time to do that, I'll let you do it. But you got to pay the fee because I ain't paying it because you waived it. That's my answer. I'm done.
Okay, that would be refreshing if you were. So you are alleged to have violated 1692I. Alleged.
That's what you
Correct?
say.
And that's for you filing against Mr. Ward in the wrong district, wrong venue, wrong jurisdiction, and you yourself believe it should be in the 48th District Court.
No, I think it's proper because you waived venue. So the
Okay.
venue is proper in the 43rd District Court, and I don't know why I'm being sued over that today.
All right, so if you let me, I'll tell you.
Lovely.
Do you know what strict liability is?
Yes.
All right, you understand that the FDCPA, the particular violation you're accused of violating, is a strict liability violation? You understand that?
I do, but also...
Yes or no?
Yes, and...
That's all I want.
Your client has to be damaged by the venue violation, and if your client and you agreed to the venue and didn't waive it, then there's no liability,
Why
right?
do you believe that he has to be damaged?
That's what the Supreme Court said.
Which Supreme Court said?
The U.S. Supreme Court, Article 3 standing, Spokio and the progeny, that you're trying to circumvent in this lawsuit.
So I've read Spokio, and I think you called it the progeny.
Yeah.
And you are talking about tangible damages or violations. In the Spokio case and then in the Ramirez case, it talked in terms of what could be considered an intangible violation. Meaning, you're saying no damages as though emotional damages is not a damage. Reputation damage is not a damage. So it isn't fair of you to allege that he doesn't have damages until, like you said, you've done his deposition to find out if he has emotional, reputational, or even financial damages. I would like you to stop saying he doesn't have damages if you're going to quote Spokio, which is 6 years ago, incorrectly, as opposed to Ramirez, which outlined specifically that Spokio didn't go far enough, to your credit, but you still can have intangible damages. And you are incorrectly citing the standing law. I've won cases strictly on non-financial damages, because embedded in the rule is common law, natural law. And you just make this about money, which it isn't about money. You, sir, are alleged to have violated 1692I. And we've really been going over all this on the ways that Mr. Ward is alleging you did that.
Okay.
Do you believe that offering a change of venue eliminates the fact that you violated the law, a strict liability provision?
What I'm saying is, if this was such a big deal for your client, we would have changed the venue. You would have done it. You would have done something. You wouldn't have said, oh,
Back to my question.
I'm good at, I'm not done answering your
Okay.
question. And I know how you win cases. You lie, you fabricate damages, you make your client do things that aren't necessary, so then you can come back in your affidavit and say, whoop-de-whoop, we got Article 3 standing. And to be honest with you, in your initial disclosures, you never gave me a scintilla of anything remotely representing any damages that your client suffered.
Back to my question, and the question was quite simple. Before you literally defame me on the record,
I have to tell.
and you will be hearing about that.
I have to
That's
tell
on
the
record.
truth.
You will be okay. Truth is a defense. I understand, but you've done more than that, and there are certain provisions under the professional code that you way went over the line with that. I'll leave that alone for now. What I would like you is to answer the question, and the question is 1692I vitiated, stopped, fixed in any way once the strict violation has occurred?
First, I want to say there's no defamation action because this is a deposition. I'm not broadcasting any opinions about you personally. And if you put this on YouTube, which I've told you not to do, that's your problem.
Do you not see people in here that you keep referring to as 5 against 1? You just defamed me to them.
Oh.
Take away the film. You literally just violated Michigan law.
Oh, well,
So
then
here's what we're going to do on the record.
sue me.
Now you listen to me. You will place on the record now, I'm giving you the chance to take that back, that I'm a liar.
No,
Okay.
that's my opinion,
Okay.
and I got proof.
Okay. So
If you don't take it down
have
from your
not
page.
answered my question. You've not answered my question.
Sure, go ahead.
Do you believe that once a violation occurs, it can be vitiated or fixed?
Yeah.
How?
It's not a big deal because you and your client waived venue and you said, okay, we're good with Madison Heights. We don't want to change. We don't want to go to Bloomfield. Because if you could, you would have done it.
But you did this letter, for example,
Yeah.
and your attempt to change venue.
No, I didn't.
Let me finish. Was done way after you filed in 43rd District Court, and I did, as you say, a counterclaim based on that. And I did that before you sent this letter. So you were in violation according to Mr. Ward. I'm asking you again for the last time, and your non-answer is I don't really know what your answer is. For example, let me do this so you understand it. If I break into a house and steal something, have remorse about that or whatever, I break back into the house, fix the glass I broke, and return the stuff. Am I still guilty of burglary? Yes or no?
I don't know. I'm not a criminal law attorney. I
All
don't
right.
know who would press charges if you brought the stuff back.
So it's okay as long as you fix something, you can break the law.
Give me a break.
Right, it's a silly thing to say, isn't it?
It is a silly thing to say when
So
you fabricate a lawsuit
Right.
based off nothing. I'd send a prophylactic letter to you saying, okay, I know what you're doing. Let's just change the venue right now before you sue me.
Fair enough.
And you said, I
So-
refuse to change the venue.
Is changing the venue gonna fix your violation in your belief under the FDCPA?
It should. I don't know why this venue is bad in Madison Heights. I think you'd have more problems in Bloomfield Hills if you want to be perfectly honest.
Okay.
Because I think you got problems with some of the judges there, like Judge Small.
I think you have, for the first time today, I agree with you. I've tried the same case in 48th in front of Judge Small and tried the same case in front of Judge Kuhn. Completely different outcomes.
So
you're exactly right.
So the venue was good for your client. Is that what
Right.
you're saying?
It would have
In
been
Madison
good
Heights?
if you lived there, yes.
And it was better than Bloomfield Hills for you and your client. Is that
Well,
true?
I can't speak for my client, but if I was in the wrong place, I filed a lawsuit in the wrong place, I don't get to fix that mistake by yelling mea culpa.
You could have brought it up in your motion. You could have followed the court rules and said, told Judge Hunt, this venue's wrong. Make Security Credit Services pay the venue transfer fee and we'll get this out of your hair.
So-
and you did not do that.
Can I say this then?
Sure.
And then we'll move on.
Yeah.
If a law is broken, but somebody fixes what was ever broken in the FDCPA, the violation, a strict liability violation, goes away.
There's no damages here.
Yes or no? Does it go away if you attempt to change venue later on?
It should.
Okay, I'll take that as an answer. You,
That's what a jury would decide.
well, how do you know what a jury will decide?
Because I've talked to people about this case and they're like, why are you being sued? And then I tell them and they're like, are you freaking
Jury-
kidding me? You can be sued for that?
Jury members,
Just regular people, regular
are
folks.
they normal?
I don't know.
Okay.
I'm associated with them, so they're probably off the wall.
Probably normal, right?
Yeah.
So let's go back to your affirmative defenses. You
Okay.
highlighted the bona fide error rule. You don't have to stay here if you don't want to.
No, I'm looking at the.
Okay, I don't want you to be, I just got to do my job. So
No,
the
what's
bona
your
fide error
job?
rule requires that you, if you are found to be in violation, you can, if you will, can get out of it if you showed reasonable maintenance of procedures. Correct?
Sure.
So in your case, you said that when Miss Underwood said, you got the wrong house, he doesn't live here, the way, I think I used the word protocol with you, the protocol, and I'm talking about Exhibit 5, page 1, is that the gentleman that you do a lot of work with, Mr. Sutherland, he goes and asks the apartment complex, especially when it's an apartment complex, because of the great difficulty. But you said you found that he did not do that, and you did not know why he did not do that. Is that correct? That was your testimony?
That's my testimony, yeah.
Right. So how was,
Here's the- So.
when I asked you, same question, when I asked you, how come you didn't follow I, you were adamant that I does not apply. And you said, Parker, you got it wrong. I said, would you like time to research? And you took the time, and you went to J, you remember? And you had me read J.
Yeah.
Is that correct?
Yeah.
All right. J is, and I'll read it again, and you emphasized this before saying anything further. You said, I like this phone. Discretion of the court. You said that meant something. You said, on a showing that service of process cannot be reasonably made as provided by this rule, the court may order permit service of process to be made in any other manner reasonably calculated to give the defendant actual notice. So contacting Miss Underwood's management company would be a way to reasonably try to find out if she's lying or not, because you said you didn't believe it because I just don't believe people.
No, I didn't say that.
Then why didn't you do what was reasonably calculated by having Mr. Sutherland contact the management company, especially with your belief that it's always difficult? Because you said I doesn't apply, J applies.
Right.
So let's, going by what
J-
you said, how was that reasonably calculated to find Mr. Ward?
Because we do these motions all the time, and that's the standard. You
Did I say that right? No.
See it?
Yeah.
Well,
What is going on?
reasonable calculation. You said that normally people, the server actually goes to the management company. And
Sure.
when he goes to the management company, he asks, like, hey, what's going on with the defendant's location? you said this didn't happen in this case.
Uh-huh.
So would it be technically reasonably calculated under those circumstances when it's not being done like it normally is being done?
Well, I'm going to tell you and Mr. Parker, if you look at the times that Mr. Sutherland was at this location,
3 times, yeah.
3:38 p.m., 8:01 a.m., 6:27 p.m. I don't know if there's a leasing office there. I don't know if a leasing person was in the building at the time, if there was a super, if there was anybody. I have no clue.
So you had no clue, but you went ahead with the judgment anyway.
Yes, because we had a signed green card from an agent of your client, because we had his car was registered there, because we had a good postal verification, because it was the most current address in the system, because his only other address was his parents' house, and just kind of using common, and again, this is not true for everybody, but just kind of thought, man, he's not going to move back in with his parents. Just like you said off the record, your client makes a lot of money, so it's hard to figure out why he would move back in with his parents. Again, I don't care. That's not for me to decide, but reasonably, if it was between Ferndale and Bloomfield, we're going with Ferndale. I'm sorry.
Okay, so you said there's 3 attempts being made,
Yeah.
2 of which there was no answer. Those 2 of which there were no answer, you could have, contacted the management company.
Yeah.
The third one, or either the 1 out of the 3, the resident at that apartment said that guy does not live here anymore.
Okay.
And then, so you're saying that it's not reasonable?
Are you licensed in federal court, Eastern District?
I'm asking you, do you think that is it reasonable, you were testifying before, that it's reasonable for your servers to go to management companies? Especially
I
when...
didn't say that. I said I usually see them do that on some of the motions.
You said all of them.
I didn't say all of them. Obviously, I didn't say all of them because he didn't do it on this one.
All right, so at
But
302...
are we still... I thought we...
It's not, he says that it's not reasonably calculated. 159, he says it's supposed to be reasonably calculated.
This is unbelievable.
So, is it reasonably calculated to give the defendant notice, or it isn't reasonably calculated?
This is what Judge Hunt ordered, so that's what he thought.
No, it's saying you can go do something. You've got to be reasonably calculated to obtain service.
It's better.
So which one is it?
It's better than publication in the free press. That doesn't do anything.
Didn't answer my question.
We did what we had to do to get a judgment.
And was it reasonably calculated
Yes,
to get him the
absolutely.
best possible chance of getting service?
Absolutely.
Even though you didn't talk to the management company, and you had the person that lived there saying there's no ward here.
Again, in the environment we're in, especially with you telling your clients don't accept service, don't cooperate with them at all. It's just the environment we're in. People don't want to be served. People will cover, people will lie, people will say things that aren't true. I've seen it every day in my office, and I'm sure any collection attorney could tell you the same.
So are you saying I represented Mr. Ward in March 15th, 2023, and he purposely told Miss Underwood to say that he didn't live there? Is that your testimony?
I'm just saying, based on my vast experience doing this every day, that people do cover for other people. It's not outside the norm. And when a postal verification, when mailings to this address aren't coming back, when it's the most current address in our system, when his car is registered there, I don't know. There's more likely than not he's there. That's my calculation.
Okay. Is telling your Mr. Sutherland that he must go to the management company, would that be part of your, let me quote, the maintenance of procedures reasonably adapted to avoid any such error?
I don't know. I don't know if there's a leasing office there. I have no clue.
All right, but
I haven't been there. Have you?
You're saying affirmative defenses, you are entitled to be protected by the bona fide error rule because you set up the maintenance of procedures that are reasonably adapted to avoid any error. So,
yeah, we've gone over this.
Did you tell Mr. Sutherland, as part of your maintenance of reasonable procedures to check with the leasing company.
No, I didn't tell him anything. But
Right.
again, when everything is showing that he lives there and we have a denial of occupancy, as I've said and I'll say it again, a denial of occupancy does not mean we are throwing up our hands and saying, oops, he doesn't live there.
So your procedures don't include telling Mr. Sutherland or any process server you use to go check on the management company, especially with leased apartment complexes.
No,
that correct?
that is correct. We don't tell them to do that.
Okay, why not?
I don't know.
Because you said it's a good idea.
Because they do, they're a great client for us. They know what they're doing. They do what they have to do.
Number 7 of exhibit, what's, you have the affirmative defenses and answer?
It's Exhibit 11.
Okay, thank you. No need to be snippy.
Yeah.
So number 11, what
Number 11 what? Just go by page ID.
Oh, look at number 7. Plaintiff's claims are barred by an agreement to arbitrate.
Sure.
That's part of your affirmative defenses that you signed off on as being true.
Sure.
Could you point to the agreement to arbitrate?
Let's see if there is one.
Well, you said it's true, so why wouldn't
You
it?
plead a lot of affirmative defenses so you don't miss one. Okay? That's what I do.
I can see that you where this is going. Okay. But
I don't see any, well, let me look further.
you've already looked.
No, I haven't.
Yeah.
You don't like arbitration anyway, so.
So you have pled something that isn't true.
It's a defense. I don't know if it's going to actually work. I don't know if all these defenses are ones that are going to work in this case. But you still plead them so you don't lose them.
No, you don't.
Oh, okay.
You plead something that's true. Is that correct?
I don't know if he had an arbitration agreement with Realimax. I don't know any of that. I'm not going to strike any affirmative defenses at this deposition
asking
if
you
that's
to.
what you're asking.
I'm saying, what is the basis of, and it's a great question for me to ask, I'm entitled to, it's a pleading. You've told the court that these claims are barred by an agreement to arbitrate.
Sure.
What's the basis of that you have signed your name to?
Usually there are arbitration agreements. I don't know if there is one here, and I don't know if he had an agreement to arbitrate with Realimax. I haven't seen that, but I'm not gonna just strike it.
But you're also not going to put it in a pleading if you have no proof that's the case.
I'm putting you on notice that these are my affirmative defenses. I may not use all of them, but I'm putting you on notice that I may.
All right.
Thank you.
Is that the rule? You put things so that they're giving the other side notice? Or is there a requirement of an element of proof and truth that you put into this?
I don't know.
You don't know?
I put it in there. I don't know if there's an arbitration agreement or not, but I'm not going to just not say and lose that defense. Are you really? And what you put in your pleadings is a joke.
Do you have access to the loan agreement before you sign and put in a federal court filing that you have an arbitration agreement? Did you have access to your own lawsuit?
I have access to the documents I have. I don't know if these are all the documents that are associated with the student loan. I don't know if he had a separate agreement with Realimax. I have no clue at this time.
Okay, so you're saying he had an agreement with Realimax?
I said I don't know.
I know.
But I'm not going to waive affirmative defenses, and I can reserve the right to assert further defenses as discovery commences.
So,
if I knew all the answers without discovery, then, you know, why would we even have a lawsuit?
Again, we just painstakingly went through your complaint.
No, you didn't.
Exhibit 1.
Okay, Exhibit 1.
And we went over, I said, hey, here's your loan agreement. You corrected me and said, no, that's his application. Here's his loan agreement. It's your lawsuit that you attached
Dun, dun, dun.
where, before you filed the affirmative defenses, a federal court case, was the arbitration agreement that you are referring to that you don't want to lose.
I don't know. I don't have
take a
it
look.
here.
It's your filing. It's your lawsuit.
I don't know what's out there. I don't know if this is the whole document, okay?
Is there more to the agreement?
I don't know.
Then why, if you did not know, did you tell a court you have the right to claim that as an affirmative defense?
Because it's an affirmative defense and I'm going to claim it. And if it's not true, then I'm not going to use it further.
So you understand that I have to investigate every affirmative defense that you make. Is that correct?
And did you invest? Oh, sure. Go
Yeah,
ahead.
I
Do
read
whatever
what you gave me.
do whatever what you want to
So-
do. Did you read my Rule 11 motion?
Yeah.
Okay.
And it does not say anything about an arbitration agreement.
Sure.
But in the answer, I think you've broken the court rules about alleging something that isn't true, and you've signed.
I
And
don't.
isn't it fair to say that you had that lawsuit and agreement and the ability to call your client and ask them if there's an arbitration agreement? Is that correct?
No, my client is not Genesis Credit Union. I can't call them and ask them for anything. I'd have to
Right.
subpoena it. And if I subpoena it and there's no arbitration agreement, I will strike it.
That's not what I asked you.
Well, that's what I'm
You have the ability
saying.
to talk to Genesis.
No, I don't. Are they my client? Do they? I don't represent them.
You can literally talk to them or subpoena them before your answer's filed.
Yeah, and am I going to get that in the 21 days? I don't know. I pled this, okay? If it's
Why are
wrong,
you
I'll
saying
strike
21
it.
days?
I have 20 because you served me with a lawsuit and I have to file a response within 21 days. And discovery wasn't even. Oh, I have to do initial disclosures before I can do any discovery, right?
In state court,
And we're in federal court right
yeah,
now.
you meet with the court and you go
Yeah.
over the discovery.
So
plan.
I couldn't.
That's
I
how-
could not subpoena Genesis Credit Union at the time I filed this because we hadn't done our initial disclosures yet.
Why not do it in the state case?
Because on April 10th the case was closed. You settled it with your client.
No. Why not during the state court case did you not contact your client that you claim has all the documents, or Genesis with subpoena power?
I don't know. We still got your client to pay us, so.
I'm asking you why you did not.
Because I'm busy. I don't have
busy.
time for this. Go wait for your next question. Here it comes.
Could you exhibit, where are we up to 13 now?
13.
13, make exhibit 13.
Are you claiming no representation?
I'm handing
I
you-
represented Security Credit Services LLC. They are not Genesis Credit Union. I don't know what relationship, if any, Security Credit Services has with Genesis Credit Union.
Did you ask?
I'm not getting into that.
So you didn't ask
I'm not.
your client to produce an arbitration agreement that you said is valid in a federal court filing?
I'm not talking about anything to do with attorney-client.
Let's hand you
Obviously.
what's the counterclaim,
Sure.
and there's affirmative defenses. Would you please, and this is from the state court case that you filed September 6th, 2023. Could you read to the court, to the record, what you claim barred my client's claim at number 3 of the affirmative defenses?
3, defendant counterplaintiff's claims are barred by an agreement to arbitrate.
So that's another court that you're misrepresenting something that isn't true, or you don't know or don't have the proof about. Did you, prior to, in this case, you actually signed your name to this?
This case is over.
you said you wanted me to stop interrupting you. Did you contact your client or anyone prior to saying in a state court proceedings that my client has no claim because of the arbitration agreement that you failed to show? In the same case, by the way, that you've got a loan agreement you can read. Let me rephrase.
I'm just looking at this.
Did you contact...
Go ahead.
Did you contact Genesis to see if there was an arbitration agreement?
No.
Did you contact your client?
I'm not getting into any attorney-client privilege.
I don't want you to.
Then I'm not answering.
Were you provided with an arbitration agreement in the loan agreement?
No.
The loan agreement, Exhibit 1? No. Then what was the basis of your telling a court that you have a right to seek arbitration of the counterclaim of my client?
Because you put that in.
Who's you?
Me. I'm an attorney. I put this in.
So you should know better then.
Oh, I don't know if there's an agreement to arbitrate. I don't know if the documents my client provided me are everything. I don't know that. Okay? It might be out there, it might not. Obviously, we didn't file a motion for arbitration in this case. We settled it. There was no problem. You never brought this up. It wasn't a big deal.
The problem, as you say, as I see it, is that you violated the signature rules by signing for something that wasn't true and you had no evidence of.
Then go tell the bar.
I don't like to do that. If ever a case, especially with the defamatory statements, but that's another day. If you would, go to Exhibit 5.
I will if I have it. Oh, Exhibit 5. Here we go.
And find, I think it's page 4 or 5, the green card.
It's page 5. Go. Back on the green card.
So that I don't have to look for mine. Let me just see it. No, I don't want it. Please don't throw things at me.
Oh, sorry.
Okay.
It's been a long day.
You see the Exhibit 5, page 4?
I see Exhibit 5, page 5.
All right, page 5. Go to
Thank
that.
you. I'm here. I've been here.
And go to the back of Exhibit 13, assignment and bill of sale.
Okay.
You see the signature?
Yeah.
Now look at the signature on the card that you sent to court. Do they look strangely similar?
You're really
To
on,
you.
You're really on one.
I'm asking you a question.
No, this actually on page 5 looks like your client's signature. So, are you really accusing me of this?
I did not say that to you.
Oh well, I know where you're going, and if you're, I don't know if they do that at Shermetta or not, but we don't do that at my firm. Ever. We don't fabricate evidence and damages like you do.
You're saying now that I fabricate evidence and damages?
I put that in the Rule 11 motion in the reply, so it's out there.
Okay.
Yeah,
So let me hand you...
and I think it's true because you never even responded to the Rule 11. You just kind of pushed it off because I think you know
You didn't get a response?
you got caught. Well, you didn't really address any of the allegations, and you just kind of said, "Oh, yeah, it's too early for this. We should do something else. Oh, we don't know who's drafted this writ of garnishment objection. Well, we gotta wait till discovery," even though you and your client both know the answer.
So, you're saying that there was no similarity between the signatures of page 5 and the assignment of this attached to Exhibit 13?
No, there's a whole different marking on 5 that's not on this signature on Exhibit 13. This page isn't marked, but I'm just going to say it's the assignment and bill of sale.
Can you tell me...
They don't look the same at all.
All right.
I'm going to put them on video. Here's one. You can see it for yourself. And now you can see this. And you be the judge. Do these look anywhere near the same? No, they don't. Thank you.
Is this another case where you think people know that you're watching them?
What? Well, you're accusing me of signing a green card and
make this
violate.
Exhibit 14?
If you have proof of that, please let me know, or just go to the bar. But unless and until you do, I'd appreciate it if you don't insinuate that I fabricate signatures on a green card. I don't know where you got that idea from. I don't know if it's part and parcel of your practice as an attorney, but I don't do that.
You're asking me where I would assume that you fabricate things? I just showed you Exhibit 13 and 12 regarding your telling the court that there's an arbitration agreement that doesn't exist.
I don't know if it doesn't exist, but I'm going to
Okay.
go through all your pleadings, and I'm sure they're up to snuff.
Can I hand you? They're not. Can
I
hand
know
you
that.
14 arbitrate. This is what you provided me.
Yep, and I'm going to reference something myself. So go ahead, ask
Okay.
away.
So the. By the way, you don't get to introduce documents into a deposition.
Oh, I'm going to reference it myself. So don't
All right.
tell me what to do.
I'm not accustomed to objecting. Anyway, so
I gave this to you, so you can have it.
So Exhibit 14.
Sure.
We received
Fire away.
from you. I think it was a mediation summary,
Yep.
and your claim is that this proves that a payment was made on the debt. Is that correct?
That and your client's credit report. Yes.
Okay. So you are saying a payment was made
Many payments were made.
based upon an account history.
Right.
Who
Yes.
created this account history at Exhibit 14?
I have no idea, but Genesis Credit Union on your client's credit report listed a last payment date of May 7, 2017, and I have that.
Okay.
So they reported it to the credit bureaus, and looks like your client at no time objected to that representation on his credit report. Thank you.
All right. So you have a document that you are saying that you gave me and proves that a payment was made of $25 on an $11,000 claim, correct? By my client.
I'm showing many payments of nominal amounts, yes.
And
all the way from 2012 all the way to 2017.
And I provided you with an affidavit that my client signed under oath that he's made no payments.
That's great. I'm going to give you a little axiom from Benjamin Franklin, the Farmer's Poor Richards. Creditors have better memories than debtors. You ever heard that one? Look it up.
I don't.
Well, there you go. It's still good to this day. Good old Benjamin Franklin.
So you have this document. It's called an account history. You don't know who created it?
No, but I'm assuming it was Genesis Credit Union, but I don't know. And again, Genesis Credit Union reported this payment on your client's credit report, so I think it was them.
You keep referring to something. May I see it?
I already gave you a copy, but here's another one.
I don't know what you... Let me see this.
There you go. You should have looked at that before, because I gave it to you. And we didn't put any debt on your...
You gave it to me today.
Yes, I did.
So you wanted me to stop and take even more time to read this and then have you complain how come you're taking my time?
No, I
When
gave
you could have
this...
given this to me. Let me see. It says it was pulled 5/26/2023. Whoa, that's over a year ago. Why did you not supply in the state court case and the federal court case until now? You held it back.
Well, I'm
Why
giving
is
it to you now. I forgot we even had this. I'm sorry, but you have it now. And since you referenced your client's credit report in your amended complaint, I'm assuming your client already has his credit report, right?
I don't know what this is.
It's your client's credit report that we pulled after we got the judgment, and you can clearly see Genesis Credit Union, not me, not Timothy Baxter and Associates, not nobody but Genesis Credit Union reported the debt on the client's credit report. So is that allegation going to be removed from your amended complaint? I don't think so.
And where is this that you're saying this occurred?
What?
That they reported that he made a $25 payment?
If you look at this right here, Genesis Credit Union.
The first page?
First page,
Okay.
middle, 517. Do you see that?
It says $75,000.
Go to the left. Other column to the left. You see a 112, you see a 4118, and then you see a 517. 517 is the last payment date.
Where
May.
does it say that on the credit report you just handed me?
The column right above, it says open, balance date, last PD. That means last payment date. In my understanding, and look, it matches up with the payment log 100%.
So how much does he owe?
He owes nothing now.
How much did he owe when you were reporting he made a $25 payment?
I don't know. 25 less what we sued him for?
What was it on the account summary?
I don't know.
Yeah, you do. It's right in front of you, Exhibit 14.
$11,817.22 is the principal balance.
Okay.
There's interest as well of $667.45.
And this says...
I don't know if there are fees as well. I don't know that.
This says $75,000.
Sure. Yeah,
You're asking me to look at this. What does that mean?
I don't know. He took out a loan for $75,000 and he only owed 12, so I think he made some payments.
So you're saying this debt was for $75,000?
No, I'm saying that's what's reported on his credit report and he didn't object to it. That's what I'm saying. And I don't even want to get into that. All I'm saying is that the credit report
You'll get into what I
shows
ask you about.
the last payment date of May 17.
Is there a privilege that you're being protected by when I ask you a question?
Ask your next question, please.
So explain to me why, if this is correct, he owes $75,000. When I asked you, you said
Oops.
that's the amount he took out.
Well, I guess
does
we
that
screwed up. We should have sued your client for $75,000, not 12.
All right, so let's
I'm
go to
sorry.
Exhibit 1. Let's go to Exhibit 1
Sure, go back.
and look at the loan agreement.
And again, your client settled this case. Again, for like the 20th time. Where are we? What
Nobody's
page?
asking you to keep repeating yourself. Why are you complaining about the 20 times you said it?
Because this is such
So
a...
how much is he asking for? How much did he receive?
What are you talking about? Where are we?
Are you not able to understand me?
Where are we in the exhibits so I can get to
I
it?
just told you 1, and you're going through 1 because I told you to go there.
Okay,
Now
what
go,
page? What do you want me to look at?
Turn to the application.
Application, okay, page 4.
Does it say how much he's seeking?
No.
Then go to...
No, actually it says 5,000.
And you're saying he owes $12,000 and $75,000.
Yeah, well, if you look at this payment history marked as Plaintiff's Exhibit 14, you can see the initial $5,000 distribution. Then you can see an additional $1,016 distribution. You can see a $4,000 distribution in September of 2012.
And who created
You can
that document?
see a $4,000 distribution in December of 2012. Let's see. Looks like that's it.
And who created that document?
Upon information and belief, Genesis Credit Union.
And what is the basis of your information and belief?
Because it matches what Genesis Credit Union reported on your client's credit report, and this is history going back, to 2012, and Realimax didn't get this until 2018. So process of elimination, I'm assuming that Genesis created this document.
It says he borrowed $75,000. Where does it say that on the form?
What form? Where are we?
The one that you say Genesis created.
What exhibit, what page number? You're all over the
14,
place.
The one you're looking at.
It doesn't say that.
Right. But you're saying the credit report confirms that Genesis created that. Wouldn't they have the $75,000?
I don't know. All I'm saying is that there's substantiation that what's on this payment history is substantiated on your client's credit report. We didn't just make this up out of whole cloth.
All right.
Thank you.
Say so.
Yeah.
Does it say when the debt was charged off?
On your client's credit report?
Yeah.
Yes, it does. April 1st of 2018.
April 1st of 2018.
Bingo, bango. Oh, God. Oh. I'm gonna do 7 hours. Are you kidding me?
So, the agreement doesn't have $75,000, and neither does the account summary that you said is history of him paying on the agreement. Did you contact Genesis to confirm that this is theirs,
No.
Exhibit 14?
No.
So it didn't concern you that this really isn't identified as belonging to anybody? You didn't need to confirm?
Well, it has your client's name on it.
Right.
It has your client's loan number on it.
Which is?
360002154764.
And what's the loan number on the credit report?
I have no idea.
Yeah, it's right in front of you.
430000042096. That's what it looks like to me. But
Why
I didn't.
Is there a difference when you just referred that to being legitimate that it has the client's?
I don't
account
know.
number?
I didn't put this on his credit report like you alleged in the lawsuit. So you're going to have to ask somebody else.
No, I did not allege that.
Yes,
I
you
alleged
did.
that you pulled his credit.
No, you said we
You
put.
just confirmed it.
No, we said we put the debt on his credit report, which we did not do at any
Like
time.
to see what I said?
Please go
I know
ahead.
you have a history of telling the truth.
I do. Please pull out your
But we're not
amended
getting away from
and
this.
complaint.
What's the account number on the?
I already said it.
And it's different from the one, his credit report. Is that correct?
Oh, yeah, you really got us on that one too.
Nobody's getting anybody. I'm just asking you confirm that you came along and said, I'm putting this on the record.
Well,
Confirmation that he made a payment that it appears is not the loan that we're discussing today.
oh, it absolutely is, because I don't see any other Genesis loans. Oh, I do see another Genesis loan on here, but it looks
Well,
like
you certainly say things that you later should maybe apologize about.
I'm not
A lot of
apologizing
those.
for anything,
I know.
because I'm sick of this.
Imagine how Mr. Ward feels.
I think he feels pretty good because he got a great deal on his settlement, but now he's, I guess, suing me, and you've kept him here all day, even though you
He was here voluntarily.
even though you claim in your his complaint and his amended complaint that he spent days and days at the court looking over all the documents. Come to find out, he didn't miss any time from work because he works at a restaurant that doesn't open until 5:00 p.m.
So your complaint at page 2 of Exhibit 1
Did you like that one?
says it's account number 360021547764. Is that correct?
Yes, and that's the same account number that's on Plaintiff's Exhibit 14.
Right. But the credit report
Oh.
that you're claiming mirrors the account history and confirms what you're saying that a payment was made doesn't have that account number.
Yeah, do you see a number, amount type 2? Do you see that $12,586?
Yes, I do, sir.
Okay, there you go.
What do you mean by that? What is it?
That's the same amount that we sued your client for. Actually, we sued him for 19 cents less than that. So I think it's the same one. But thank you.
I don't know if.
Just move on. This isn't.
Well, please don't tell me how to do a deposition.
I clearly didn't tell you how to do a deposition.
Right.
Because this is a disaster.
Okay, you just did.
Okay.
So-
well, don't tell me how to do my job.
Why is. I can't think of another way of identifying what somebody owes than the account number. Can
Okay.
you, what's more stronger evidence of someone owing a debt? The account number. In fact, you
No.
put an account number in your complaint, so you
You
find it to be significant. Is that correct?
You know what the strongest evidence of is that a client owes a debt? Is that they pay it, which your client did. The end.
Okay, so you want to answer my question?
What's your question?
You have pulled this credit report of my client.
Yeah, after we got the judgment, and that's how we found out that, oop, he banks at Genesis Credit Union too.
All right, so can I finish my question? You said stop interrupting you.
Yeah, your questions go on and on.
The
You asked like 10
identification
questions.
of an account is the account number. Am I correct?
I don't know why the account number's different on this credit report.
Well, I don't know why you think this proves anything when it's the wrong account number. That's, you brought it up, I didn't.
I guess what I'm saying is if this is some vast conspiracy,
Nobody says a
and
conspiracy.
stop, and I just created these documents because I don't know. I don't do that ever, but since I'm being accused of that, I will say that there is substantiation. The credit report matches the payment history pretty much to a T. I don't know why the account number that Genesis put on there is different than the one on the complaint and on Plaintiff's Exhibit 14. The end.
All right, so we've looked at this. You've voluntarily given this to me. Correct?
I did
So, in a
6
sense,
hours
can I
ago. Sure,
In
go
a
ahead.
sense, you just volunteered something that shows you contacted the credit report that has the wrong account number. I did not ask you to give this to me.
Yeah, I don't
So,
care.
you remember the expression I said, be careful of the hill you want to die on? And what that means, because you've watched my videos, if you're going to have a point to make, have it supported. And so far what we've learned is that you have, and correct me if I'm wrong,
Believe me, I will.
you've provided something to support the fact that my client owes this debt with the absolute wrong account number, which, as you and I are in the same industry, it's the only identifier if somebody owes a certain account. Wrong account number, case is thrown out.
Well,
So
sure.
is this account number correct, or is the account number you put into your complaint correct? Which one?
I'm not going to...
You have to answer the question, sir.
Sure, I'll answer it. I don't know what Genesis Credit Union, why they put this number on there. All I can tell you is that the number on this payment history, the balance on this credit report, which I will admit has a different account number than the one referenced, has the exact same balance as the amount we sued your client for 2 years ago, and I'm not making anything up.
No one's saying you did in this instance.
Well, we can read the transcript. It's pretty clear where you're going with all
In
this.
this instance, I did not.
Sure. Let's get on with it. Does the 7 hours include all your breaks and confabs, or are we almost
you
done?
admit that you kept us here a while with this type of editorialism. So that does include it. Is that your point? Just to fill it up with...
I can go 9 hours. I can go 10. I don't care.
All right, well, 9 hours.
Please.
I don't have 9 hours. I'm not going to keep you here just for 9 hours. I'm going to get you out of here as soon as I can.
Sure you are.
Okay. So,
You're doing a great job, by the way. I'm gonna get my wife to get my kids because of this. Thank you for that. This nonsense.
if we could go over the list. You were made aware on March 15, 2023, in your motion for verification, that you have somebody else claiming to live at the house you were serving. And correct me if I'm wrong, but that's what it says in your motion for verification, Exhibit 5. You have presented us a credit report that now says it's the wrong account number that you've been listing and claiming to the court and to my client as his account all along, when it isn't according to the record that you volunteered.
Yeah.
Thirdly, you've received a number of envelopes or return receipt envelopes, which you ignored, and then went ahead and told Genesis, who you claim you can't contact, that this is his real address when it wasn't, when you had indications it wasn't. You said the process server, because the rule under J is that the service and attempts to serve must be reasonably calculated to get to the defendant. You admit that your process server didn't go to the management company and perhaps should have. I think that's fair to say that you did say that.
I did not say that. I said I don't know if there was a leasing person, a super, or
Yeah, you did say
anybody
that too.
in charge of the apartment complex when Mr. Sutherland was there.
You also violated the court rules in federal law, federal court, and state court,
Okay.
and admitted to me you had no clue if there was an arbitration agreement, even though you had plenty of chances to have access to them that do, and filed with your signature a document saying you had a right to present an affirmative defense that you never did. And by the way, there's a number of other affirmative defenses you did not choose to offer, but you didn't include those,
What?
fearing waiving them. So you've obviously continued, if you will, and this isn't what it is, but the word is a fabrication to explain why you claim there's an arbitration agreement that never existed. You admit that you had access to both Genesis and your client to support the affirmative defense, but you didn't. Am I incorrect?
Yes.
Okay, your objection in that regard is noted. I'm going to close now so we can get you out of here, and your wife not going to be more mad at me than it appears she is at you. You have a document that I presented you, I believe it was around 11 or 12, the assignment with the squiggly signatures.
Oh, yeah.
That I claim is similar to the one someone put on the card. Could you pull it out for me?
Sure. These are some real straws you're grasping
Well, you
at.
say it's an agent, and I'll agree with you. How's that? Are we fair? We good?
No.
Okay, we're not.
What is this?
The assignment with the squiggly
Oh
line.
yeah, the one that I transposed onto this green card because I'm evil.
Well, only one of those things is true.
Oh, lovely. Okay, I'm here with the
Got it?
green card, and let me go to the.
And then we're going to close it.
Okay.
I'm
And
sorry, you can leave anytime you want.
as you folks can clearly see, for the folks back home, this does not equal this
is
in
also not-
any concept.
We're not talking about that, okay?
Perfect. Go on. Let's wrap it up.
All right. When you did not add this to your complaint at Exhibit 1, is that correct?
We've been over this,
Is
yes.
that correct?
Yes.
So, and were you in possession of this
Yes.
in February of 2023 when you filed the lawsuit?
Absolutely, I was.
All right, so the assignment and bill of sale claims that Reliamax,
Sure.
which is hereafter called the seller, has
Yeah.
entered into a purchase agreement dated October 29, 2021 for the sale of loans listed on Exhibit A. Now, we talked about those other exhibits in Exhibit A. You did not attach Exhibit A. What is Exhibit A?
Some spreadsheet with all your clients' personal information on it, so no, we didn't include that.
And so you lack the ability to redact.
You do.
Do you lack the ability to redact?
I do, but I don't like putting that stuff in court records unless I absolutely have to. I'd rather do it in discovery and flesh it out. I
think that's good.
I don't put my
Good.
client's driver's license in a federal court pleading without any redactions at all.
Muzzle tough to you.
Yes.
So you are
And I don't
saying
violate local rules like you do.
you
7.1A.
just literally.
Oh. Well, if you can do it, I can do it, right?
No, that's not true. That's
Okay.
whataboutism that
Oh.
these guys purportedly do all the time. They get accused. I know you've identified that you're a liberal voter, and you've identified her as being a Trump voter.
No, she
That's the type of
self-identified.
political discourse that doesn't belong here. Whataboutism should not be part of this.
Okay.
I'm asking you questions about what we already have.
Sure. Go
So,
ahead.
where are you going?
Let's turn the lights out on this.
Who is Reliamax?
I have no idea.
Then how do you know that my client would have a arbitration with?
I don't know. Maybe they did. Maybe he didn't. Who knows? All I know is your client paid my client the sum of as a settlement of this debt.
You don't say. I have
And-
not heard that from you today.
And under Livonia Properties, which is a case I'm sure you're well aware of, all your arguments about assignments, your client has no standing to make those arguments.
Okay. So is that a yes or a no?
I don't know what Reliamax has. Thank you.
Okay. And excuse me.
And Reliamax isn't even in business anymore. They went into bankruptcy, right?
Which you weren't aware of till I told you.
That's right, because your client owed our client money, and we got him to pay, despite your strenuous objections. And despite the fact that you told him not to
Okay,
accept the
okay.
case evaluation
Just
award.
relax.
Yeah.
So the Reliamax name has come up in an
Sure.
assignment that you attached to the lawsuit.
Okay.
Go to the lawsuit, Exhibit 1.
Sure. Go ahead. Where? Donde? What page?
I think I have it. Oh, interesting. So let's lay this out for you.
Just tell me the page number.
It should be 20 or 21, but I think I have it.
Perfect. I have it too.
Okay, so
Because you actually did this
21.
exhibit right.
Okay. You keep saying I'm keeping you in here, but you add stuff that isn't necessary. So 21, go to 21.
Whatever. You got what you wanted.
Okay. So that says that Genesis is hereby assigning, transferring, setting over to Reliamax Surety Company. Is that correct?
That's what it says.
The assignment that you were just looking at, did we, the one you just looked at, did we put a, okay, so it's number what for exhibit what? Exhibit what?
Yikes, it's 13 and there's no page number here, but I'll just say it's the second to last page of
All right.
Exhibit 13.
The entity's called Reliamax.
Okay.
It isn't titled Reliamax Surety Company.
Oh my gosh, you got us again.
Nobody's got anybody. Do you have information that Reliamax Surety Company transferred any debt of my client to Security Credit Services, or is it just Reliamax without any indication that it's a company, which is a corporate listing or an LLC? Which company gave, if you know, the debt of my client to Security Credit Services, LLC? And before you answer, did you notice that it says LLC? It doesn't say Security Credit Services and then no LLC. Did you notice that?
If you say so. I'm kind
Well,
of
it's
tired.
written right there. Do you want me to read it to you again, or can you read it yourself?
I don't know what point you're making, but I'll just
I'll
take
get
you
there.
at your word.
The company Reliamax
Okay.
Surety Company, which is another corporate, has not assigned anything to your client at the time, Security Credit Services, LLC.
Oh no.
What evidence do you have that that debt of my client was transferred to you from Reliamax Surety Company?
He paid us.
That's what you had when you filed this lawsuit?
That's what I have now. He paid
Okay.
us to settle this.
Right.
He didn't pay Reliamax. He didn't pay Genesis Credit Union. He paid my client. So
Okay.
on this debt. So I assume he thought that my client owned the debt.
You agree that you came to us and wanted to settle it for, correct?
That's what the panel awarded, and your client accepted it despite your strenuous objections when you breached the attorney-client privilege. That's my understanding. And then
Well,
you got him another $1,000 haircut, and we settled it for...
heard him say to me, I want to accept, but Parker, you're telling me not to.
No, when you talked to me on the phone, you were like, I told my client not to. Oh, I shouldn't have said that. That's what you did. I
right.
remember.
All right. Well, we have
So
a large respect for what's in your brain. Trust me, we've been on record the whole time.
Good.
So
Let's show your videos where
there's
you're
no
intoxicated.
evidence of Reliamax Surety Company in your hands when you filed this lawsuit,
Oh my God.
sending the debt, and that's an assignment question.
Okay. Which your
That I
client...
sued you and Mr. Baxter's company
Yeah.
for not having the proper assignment.
Okay.
That you have admitted you had in your hands this document, right? When you filed the lawsuit.
What are you getting at? Go ahead.
Do you have something from Reliamax Surety Company transferring the award debt to your client at the time, Security Credit Services, LLC?
I have an assignment from Reliamax. Don't know if that is a reference to Reliamax Surety Company or not, but some entity called Reliamax. I'm assuming since there's Reliamax Surety Company and Reliamax, I think they're kind of copacetic. That's my opinion. I'm not done and finished.
Sorry,
I'm not
apologize.
finished.
Apologize.
And in any event, your client paid my client Security Credit Services
will
the
have
sum
that.
of to settle this debt. So your client, it was good enough for your client to settle it. I don't know why he's suing me on this now when it was good enough for him to pay my client some money. But
Hear me out.
yeah, I
You
would
have
love to.
received a document that says Reliamax is sending something to Security Credit Services.
Yeah.
It says that something's in Exhibit A, which you don't have.
Oh, no.
Reliamax, just as Security Credit Services, LLC, has to put its actual name in any agreement, whatever that agreement is. You don't just put,
Oh.
just like you guys, you write blah, 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 Timothy Baxter Associates, PC.
Well, our actually law office is a Timothy Baxter
All right.
PC. Sometimes we say Timothy E. Baxter and Associates PC, but anybody with a brain would know we're talking about the same thing.
I don't know that because under corporate law you have to be very specific, and anybody with a brain would say as long as they say PC, then it's possibly the same entity. Reliamax, which has a large name and uses the identifier as a company,
Sure.
has not passed anything to your client
Well,
unless you have evidence of that.
I got what I got,
Okay,
and
so
it was good enough for your client to pay my client the sum of. So I think this issue's just been put to bed.
No, this is a new issue about Reliamax. This is
Oh.
new. Do you have
Go
something?
sue them.
For example, Genesis, when it assigned the debt, it provided an assignment
Okay.
of who they assigned the debt to.
Okay, perfect.
So, my brain, I'm trying to actually make this work for you.
No.
but it's not going to happen.
No, it's not.
Did
So just stop trying.
Reliamax Surety Company, do you have evidence when you filed this lawsuit that they transferred the debt to here, Reliamax?
Again, I don't know what Reliamax means in the concept of the assignment you're pointing to. I don't know. I didn't draft any of this.
Yeah, but you relied upon it to say,
Yeah.
and I quote paragraph 5, the predecessors provided your client with the debt, so they now own it. In order for them to own it, there has to be a perfect chain of title, correct? So let's do that.
There is a chain.
Let's
Well,
do that.
Again, for the
Who
final...
owned, who's the...
Why are you
then we're
cutting
done.
me off?
We're done after this.
Thank God.
The original creditor was who?
Genesis
Genesis.
Credit.
And how do we know that?
I don't know, because that's what the loan paperwork says.
Well, the loan agreement, correct? My client signed on the line that is dotted, along with Mr. Robinson, and they received the funds. You pointed out how they received, I guess, installment of 5 and 4 and 4. You said that, correct?
That's what...
So that's a contract.
Can you just let me finish? That's what Plaintiff's Exhibit 14 says.
Okay, so you have an assignment attached to the complaint that says Genesis is selling the debt in 2018 to Reliamax.
Surety Company.
Surety
Thank you.
Company,
Yeah,
thank you.
There you go.
And when did that occur?
I don't know. Sometime after that.
It says in the document assignment attached to Exhibit 1, 1/17/18.
And I guess that's when it happened.
So we have a debt that was first assigned from Genesis to whom? Reliamax,
Sure. And
Surety Company.
my understanding is...
Can I finish?
Sure, go ahead.
And
Take
then-
it till 7.
What do we have to show that Reliamax either sent this to Reliamax Surety Company sent this to Reliamax or sent this directly to your client SCS? Is it
I-
SCS? SCS.
All you have is the documents that you're referencing. Look, Genesis drafted the assignment in Plaintiff's Exhibit 1,
to that
page
for me.
21.
Genesis did?
Yes.
Okay, fair enough.
So they drafted that. I don't know why they put Surety Company. Have no clue. But you're trying to create a distinction between two assignment documents that two different entities created. So I just think it's just kind of arguing over nothing.
You're mischaracterizing what I'm saying to you. I'm trying to create a chain of title.
Well, great. Your client paid my client even without this alleged perfect chain of title, so I don't even know why we're here.
You're saying the chain of title is alleged to be perfect.
I'm saying it's alleged to be imperfect according to you, but yet somehow...
So, Reliamax
You just-
Surety Company now has it on 1/17/18. Are we agreed?
What'd you say? I'm sorry. You keep interrupting me.
According to the assignment, Reliamax sold the debt on 1/17/18. Is that correct? To somebody, and it was Reliamax Surety Company, correct? You really need to look at it again?
Yeah, I do. That's when it's dated. I don't know when the actual transfer happened, but that's when it's dated.
Okay, so when did Reliamax Surety Company pass it on to either Reliamax or SCS? And SCS is your client, the plaintiff
I don't
in
know.
the state case.
On or about, well, this was signed October 29th, 2021, so probably around that time. There you go.
What was signed? What are you referring to?
What you're looking at. Look at
You're
the
referring
bottom.
to assignment and bill of sale?
Yes.
Again, let me ask you the question again. When did Reliamax Surety Company sell to Reliamax in this assignment?
That wasn't your first question.
I'm asking it. Go ahead.
I don't know. I don't know if ReliaMax and ReliaMax Surety Company are the same thing. I have no idea.
Is there a possibility that two different things?
Sure, but there's also a possibility that they are the same thing.
Then how do you sign a pleading again with the court saying it was assigned to your client in the state case when you just said you don't know how that debt was assigned or to whom?
Because my client told me we have this debt, we're going
I
to
thought you
sue
weren't
on it.
telling me attorney-client privilege.
Well, I'll break it for this.
You can only break it once, according to you. So are you breaching the attorney-client privilege?
I'm saying that we received a file from my client. Security Credit Services said they had this debt, they had some paperwork, and they sued your client to collect it.
Great.
Because they bought it.
Present to me the paperwork of ReliaMax Security Company
Don't.
delivering the debt to ReliaMax as a seller in the assignment and bill of sale.
You have it.
And do you don't have it?
You have it.
What is it? Point to me.
You're looking at it right there.
Well, that's ReliaMax selling to your client.
Okay, perfect. And I've already explained that ReliaMax and ReliaMax Surety Company are probably the same thing.
Do you have any evidence of that?
No, but they have the same name.
So
just-
GM, General Motors and General Motors Finance are the same company, or are they separate corporations?
They're saying they're all part of GM, right?
So they are same company, they're
Oh.
not the same? Which is it?
You got me.
No.
Look,
I'm saying
It's
you
over.
can't be similar if you're
Yeah.
separate.
great.
Okay?
Your client settled this. I'm done with this.
Until you give me an answer, and even if the answer is go fly a kite,
Yeah.
are you saying you have evidence that there was an assignment between ReliaMax Security Company and ReliaMax, who then is selling the debt to your client? Oh, I keep sniffing.
I don't know. I don't have ReliaMax's internal documentation, so I'm just going to have to say I don't know.
But is I don't know good enough to file a lawsuit against somebody?
It is when they pay you to settle it,
You didn't answer
even
my
with
question.
your attorney.
Okay.
You as the attorney.
Is I don't know the basis that someone should use, like you used with your affirmative defenses in both state and federal court, a good faith reason to sue somebody?
Yes.
I don't know
because-
is good enough?
Yes, because in Michigan, as you know, third parties to assignments have no standing to challenge the assignment of their debt.
Who's the third party in this case?
Your client, Mr. Ward.
Is a
Can you
third
stop
party?
for a second?
Sorry?
Your microphone came on.
Oh, gosh.
Do the restroom break?
No.
Yeah, I do want.
Yeah, you go this way, take a left. There's
God.
no sign.
Can we go off the record?
Yeah.
All right,
Much
off the record,
more of this
4:49
is-
PM.